And the sentence that condemns or acquits is not simply a judgment of guilt, a legal decision that lays down punishment. It bears with it an assessment of normality and a technical prescription for a possible normalization. In the CBS News interview with Gayle King, R.KELLY made the following problematic statement.
The past is relevant with you with underage girls.
Absolutely no, it's not.
Why?
Because for one, I beat my case. When you beat something, you beat it.
You were acquitted.
We can't double jeopardy me like that. You can't. It's not fair. It's not fair to nobody. When you beat your case, you beat your case.
The implication here seems to be that because he was acquitted of child pornography charges by the judicial system under the rules of due process, this means his viewpoint, his truth, is true. And furthermore, the legal prohibition on putting a judicial subject in double jeopardy should guarantee his truth a stable status as the truth once and for all. His side of the story won the day in court, which gives it a legitimate truth content. The state's case against him, including the 14 witnesses who testified that it was Kelly and an underage girl, witnesses which include the girl's aunt, basketball coach, and best friend, all of these facts are rendered false because he was acquitted. Or so R.KELLY says. Just as a note, a judicial subject is defined here as a possessor of the right to exist, to own property, to have opportunity in relation to a state. Judicial power, therefore, is a negative power against the judicial subject. We are reminded by the apologists that Kelly is innocent until proven guilty, that R.KELLY won his previous court case in 2008. This presumption of innocence is supposed to guarantee that a judicial subject has the right to exist unimpeded by the state. We are told we must suspend judgment until after a new trial has occurred. We are reassured that the purest truth regarding this matter, or a truth that is true in and of itself, can only be found within the framework of due process of law. R.KELLY and other apologists would like you to believe that the negative truth of the judicial system is a higher form of truth waiting to be discovered, and that the presumption of innocence renders facts in a state of flux until they've been put to the test of judicial practices. Due process of law guarantees a minimum of 3 things occur before the government can infringe upon a judicial subject's right to life, liberty, and property. According to constitutional law professor Elizabeth Price Foley, these are: 1 is having some sort of notice of the charges that are being levied against you. The second is having an opportunity to rebut those charges. And then the third is having some sort of neutral decision maker to hear the charges and make whatever ruling is appropriate. In the judicial system, due process is the magic armor of legitimacy that enshrouds the trial, allowing a theoretical form of truth to develop. Legal experts and rape apologists decry this era of Me Too, where alleged rapists are tried, convicted, and executed not by the cold, disaffected, almost sterile judgments of the judicial system, but by the barbarous, irrational public body itself. The emperors have no clothes on with the death of due process. Specters of rabid lynch mobs executing any accuser are conjured to scare young men.
It's a very scary time for young men in America when you can be guilty of something that you may not be guilty of. This is a very difficult time. But somebody could accuse you of something and you're automatically guilty. But in this realm, you are truly guilty until proven innocent.
But to take a step back, due process of law only applies to the government's actions towards judicial subjects, not the actions or beliefs of other individuals or society at large. Due process means the government is supposed to abide by the above set of prescriptions when threatening to limit a judicial subject's freedom. According to a law professor at Georgia State University named Andrea Curcio, due process means that you have the right to be heard, but not the right to be believed. Whether people like it or not, there are no constitutional protections against a bad reputation. However, the law does provide remedies between private parties. If someone like R.KELLY really wants to challenge the accusations against him, he could take these accusers to civil court where everybody would be able to testify under oath. However, the burden of proof would be on R.KELLY himself to prove these accusations are false. R.KELLY and many powerful alleged abusers tend to avoid this, preferring to use non-disclosure agreements and money settlements to keep accusers quiet. At the same time, a judicial trial only really establishes whether the accused judicial subject is criminally or civilly liable for an action. There are situations where a subject admits to committing certain illegal acts, but is not found criminally liable for those acts. For instance, a Catholic priest admits to raping children, but his acts fall outside the statute of limitations on civil or criminal liability. Or a person is deemed mentally unfit for trial and therefore cannot be held liable. There are also instances where someone did not commit a specific act but is found to be liable for it nonetheless. Instances like a neighbor is sued because their dog bit somebody. A getaway driver is charged with murder because another member of the criminal act murdered somebody. While due process does facilitate a kind of truth production, these truths may obfuscate what actually occurred. In some instances, truth values invented at court can change several times, or, as is much more common, the facts carry multiple truth values that contradict each other but compete over which perspective is most dominant. In the surviving R. Kelly docuseries, a white juror from Kelly's 2008 trial revealed that despite several black women, like Lisa Van Allen, testifying to the sexual abuse of minors by Kelly, the juror didn't like the way she looked or dressed, so he disregarded everything she said.
I just didn't believe them, the women. I know it sounds ridiculous, the way they dress, the way they act, I didn't like them. I voted again. I disregarded all what they said.
This is an instant where Van Allen's facts were shrouded by forms of racism and sexism. But according to R. Kelly, we're supposed to ignore these very obvious biases involved in his previous trial because it passed the judicial test? We often think of due process in a societal sense, letting the legal definition bleed over into the wider cultural, social, and political institutions. We often say, don't rush to judgment. Here, the question is not one of criminal liability, but societal liability. According to former United States District Judge Shira Scheindlin, quote, "The question is whether, given the quality of the allegations, the person against whom the allegations have been made should remain in a position of trust, confidence, and responsibility, which he, and it usually is a he, currently holds." Kelly apologists may state that these accusations are unjustly making it difficult for him to have a career, make a living, or maintain his properties. But the process due to R. Kelly by the venues that cancel his performances, or to the record company that dropped him as an artist, is very low. If promoters, record labels, and venues don't feel comfortable supporting Kelly, for instance, it may be detrimental to their own reputation and bottom line to associate with an alleged pedophile. It's because there was a judgment call to make by these groups, a judgment call that just isn't burdened with a very high level of due process. And once again, R. Kelly is free to sue any of these entities for a wrongful breach of contract, but he would have to prove that in a court of law. This video isn't about completely delegitimizing due process. Due process is a worthy thing to fight for, especially as our rights are ever more infringed upon by an increasingly large state apparatus. But R. Kelly's history of abusive behavior towards young black girls shouldn't be ignored just because his previous court case found him not guilty. Despite its ability to create truths, a courtroom is far from perfect, and far from the final say on what is true or false. Any argument placing his accuser's facts in a state of epistemological limbo until they've been tested in court fails to recognize the obvious limitations of due process. Thank you all for watching my video here at Zach's Strange Corner of Thought. If you'd like this video, drop a like, and if you want to see more content like this, please subscribe. To continue the conversation, leave a comment. Also, consider donating to my Patreon page. You can see more of my thoughts at strangecornersofthought.com.